The title, of course, of my presentation could sound contradictory, because when we are talking about mediation, we are not used to talk about duties and responsibilities. We all know that mediation is a voluntary process using which the mediator is supposed. Now, before I begin, but I have to have my, what is? Okay, sorry. Sorry. I will try, otherwise I will ask your help. So, no.
Can you raise it a little bit higher, because of sometimes, you know,
let me just.
Yes.
Here. Okay.
Trying to press this one.
Okay.
Yes.
Okay, hear him. So we all know that mediation is a voluntary process, and using which the mediator is supposed to help both parties to communicate and voluntarily disclose their interest in order to find a solution that is mutually satisfying for both of them. And in this context, talking about duties and obligations might seem a contradiction, as parties should be free to enter in mediation and leave mediation whenever they want, without facing any sanction or negative consequence for choosing to litigate their case in court instead of mediating it. So if the parties do not want to mediate and do not want to cooperate with each other, they should be free to do so, and the mediator shall have no power and no responsibility to bring the parties to settle the dispute if they want to keep litigating it. This is the theory of mediation, and in many systems, it is also the reality of mediation. But on the other side, experience teaches us that the parties in dispute rarely choose to mediate their dispute. For many reasons, they either negotiate by themselves, or they prefer to bring the dispute in front of a third party, the judge or an arbitrator, who will decide who is right and who is wrong. Notwithstanding the advantages and benefits of mediation that we all know, parties tend to prefer the hardest way, putting their dispute in the hands of someone who will decide for them, instead of taking the responsibility to decide from themselves. Many factors might contribute to this conclusion, and some of them have been already discussed about, so I will just mention them. The cultural factor, the lack of awareness about mediation and mediation advantages is one of the main reasons. The role of lawyers, we have been discussing about there before. I can add from the Italian perspective that the opposition of lawyers might grow, might increase in those countries where, as in Italy, we have many lawyers who are struggling to develop their professional activities, and of course litigation sometimes might be more convenient for the development of their professionalities, and also from the perspective of their compensation, I have to add. But then we have also personal factors, distrust over the process and distrust over the other parties. Even when parties know what is mediation and lawyers are open to it, still parties might avoid it, as they don't want to cooperate with the other party, as they consider the other party an enemy, and they don't want to think that, given the situation, mediation could be successful. So for all these and other reasons, we might conclude that, in general, mediation is not the default paradigm for most individuals who are involved in disputes. So in order to change this attitude, many legislators are introducing mechanisms designed to force parties toward mediation, or at least to strongly promote and suggest parties to use mediation instead of litigation. Why? Again, we can indicate different reasons. Some of them have been already indicated, but in order to simplify, we can reduce them to two sets of consideration. Legislators are promoting mediation because mediation is better than litigation in terms of social and individual well-beings and of social relationships, and we can label these as the educational consideration. So the state says, even if you don't want to mediate, I force you to mediate because this is better for you, even if you don't know or if you don't think so. But on the other side, legislators are promoting or forcing mediation because they want to unburden the court systems, moving disputes outside the courts to an alternative dispute resolution mechanism. And I can label this as the efficiency consideration, where the state says, well, even if you don't want to mediate, you have to because litigation is too expensive for the state and courts cannot deal with all disputes and conflicts arising out of social and commercial relationships. Both considerations might be acceptable and somehow agreeable, and as I said, they have pros, but they also have negative implications and cons. And the importance and impact of these pros and cons strongly depend on the mechanism, the regulation models that is adopted by the state in order to force or promote mediation. From the perspective of the parties, we can identify at least 4 fundamental strategies or regulation models along a continuum, I would say, from the less intrusive into party voluntariness to the most intrusive one. We can identify legal mechanisms that introduce a duty to consider mediation or a duty to attempt mediation with variation, such as a duty to participate with settlement authority, a duty to pay the fee, a duty to appoint a mediator. And then we can have a model according to which there is a duty to attempt mediation in good faith, presenting documents, making offers, negotiate in good faith. And finally, we can imagine a duty to settle. So legislation varies introducing mechanisms that require parties to satisfy some of or all of these duties or standards and to take some of or all of these standards of these steps toward the settlement of the dispute. On the other side, we can imagine different referral mechanisms that also imply different options. Again, with different variation inside. So for example, the legislation might simply promote mediation by giving force to contractual obligation assumed by the parties. This is the mediation clause. This is a very light obligation as it leaves to the parties the choice about if they want to mediate disputes arising out of the contract and which kind of disputes arising out of the contract they want to submit to mediation. Then we have the model according to which the power to select the disputes for mediation is given to the judge. The so-called judicial referral model. See, it's up to the judge to order the parties to consider or attempt mediation, again with different options with regard to the appropriate timing in referral and the choice of disputes. And finally, we have the legal provision model according to which it is up to the legislator to establish which disputes will be subject to mandatory mediation before starting litigation. And once we have identified the duty, the kind of duty and the referral mechanism to mediation, we can also identify different coercive models. So we have legislation promoting mediation through incentives for those who attend mediation or settle the dispute. This is not really forcing mediation, but it's more a strongly promotion of mediation. Then we have models who use more coercive sanctions, such as monetary sanction or legal cost against those who fail to attend mediation. And another strategy to promote or force mediation is to establish the possibility for the judge to draw negative inferences in court against the party who violates the duty to mediate. So in those countries where legislators, for one reason or for both, has decided to force mediation, we will find some sort of combination between the different models and options and regulation models I have mentioned, also depending on the structure and on the rules governing the civil proceedings. And these different combinations might have different impact in terms of pros and cons. On the pros side, we have a general increase in the number of mediation and a sensible decrease in litigation in court. And this allows mediators to gain practice and experience in mediation. And so also parties have the opportunity to appreciate mediation and maybe in the future choose mediation as the default mechanism after they have tried it. Maybe they want to retry it in another dispute. On the cons side, though, we assist to the risk of a sort of genetical mutation of mediation. Not only the voluntary nature might be limited or compromised, but also the informal and confidential character of mediation might be wounded by this kind of mechanisms. So given these premises, in order to measure, to give you the measure of, in one system of these pros and cons, I would like to briefly illustrate the Italian model of mandatory mediation and how it fits in the categories in the models I've just illustrated. Well, I will just begin with a short description and some general definition of the Italian mediation model. It is regulated by the decree number 28 of 2010, as it was amended in 2013. This legislation has been enacted in order to enforce the directive number 52 of 2008. But as in many other systems, the scope of the legislation is not limited to cross-border disputes, but it also refers to internal disputes between Italian parties. As I've mentioned before, one of the aims of the Italian legislators was undoubtedly to reduce case loads in courts, the efficiency factor, as we have a very impressive number of cases pending before the courts that cause inefficiency and unacceptable delays. Before 2010, but at the same time, this regulation gave a very important opportunity to mediators. Before 2010, mediation was almost unknown, even by lawyers, while nowadays mediation is obviously known and practiced by lawyers, taught at the university, and also promoted in the business community. Just a few definitions, because in the legislative decree, mediation is defined as the activity, however named, carried out by an impartial third party aiming to assist two or more parties in finding an amicable solution to the dispute, including, this is important, the formulation of a proposal for the resolution of the dispute. And we will see how this proposal might work. Conciliation here, it's not a different kind of dispute resolution mechanism, but according to the Italian terminology, conciliation means the agreement reached by the parties at the end of a mediation process. Then we have mediators, of course, the person who individually or collectively conduct the mediation without any power to make binding decision or judgment for the parties. And it is important to underline, just to connect to the other presentation, that according to the Italian legislation, mediators might have to be registered, but might not operate as individual professionals. They have to be enrolled by mediation providers, that is public or private entities where the mediation procedure takes place according to the legislative decree. And also these mediation providers also have to be certified and registered in the Ministry of Justice roster of mediators providers, and they operate under the supervision and control of the Ministry of Justice. Mandatory mediation is not the only way parties can get to the mediation table, although it is definitely the more important one. We have voluntary mediation, of course, for any dispute concerning disposable rights. We have the mediation clause, so the option of giving effect to the mediation clause has been adopted by the Italian legislature, giving force to the mediation clause. So if one of the parties to a mediation clause doesn't attempt mediation before going to court, the judge can stop the proceeding. Then we have court-ordered mediation, according to which the judge can order mediation to the parties as a condition for the continuation of the proceedings, and for any kind of disputes, civil or commercial dispute, whatever is the value or the subject matter. And finally, we have mandatory mediation as a condition precedent to trial in certain civil matters. These are the subject matters in which mediation is mandatory in Italy. These are very different subject matters. With some of them, mediation is working quite well. I'm talking about real estate, condominium, it's not easy, but it's working. Inheritance, wills, and family agreements, it's working well. While, for example, medical malpractice, insurance, financial, and bank contracts, it's terrible. It's not working, I can tell you. I will show you some statistics, and if you're interested, I can show specific statistics about that, but I can tell you that insurance, financial, and bank contracts is not a good subject matter for mediation, at least in Italy. What if the party does not attempt mandatory mediation? Well, the attempt, as I said, is a condition precedent for judicial proceeding. So failure to comply with the condition precedent shall be raised by the defendant or remarked by the judge at the first hearing. And where the judge finds that mediation has not been attempted, then the court shall postpone the trial and schedule a next hearing after 3 months, so that parties might duly attempt mediation they didn't attempt before. And if they don't attempt mediation, the judge will dismiss the case. Of course, if at the end of the mediation the parties reach an agreement, the case will be definitely dismissed. Otherwise, if after the mediation parties have not found an agreement, the trial will continue at the scheduled hearing. But what does exactly mandatory mean according to the Italian legislation? Is it a duty to mediate, a duty to settle, a duty to consider mediation? Well, according to the legislation as amended in 2013, before starting litigation, the party shall file a mediation request, stating facts and reasons for the claims with the provider located in the district court. The provider shall send an official communication to the defendant indicating the date and location of the initial mediation session. If the opposing party doesn't attend this initial session, the mediator shall simply draft a certificate stating the absence of the opposing party. This party who did not appear at the initial session will face sanction in court. These are monetary sanction, but also negative inferences, as the judge could consider this behavior in deciding the case. If both parties are present at the initial mediation session, the mediator shall explain the nature and function of mediation and then discuss with the parties the possibility to entering into mediation. If the parties agree to proceed, then the mediation shall effectively begin, and parties shall pay the mediation fee. If the parties do not proceed after the initial meeting, the mediator will end the proceeding, and parties can start litigation without sanction, even though I have to say some courts are sanctioning with costs parties who participate at this initial meeting with bad faith, for example, sending just the lawyers to say we are not interested. So when we are talking about mandatory mediation in Italy, we have to be cautious because I can say that this is not really a duty to mediate. It is a duty to participate to an information meeting held by the mediator, who is already acting as a mediator, but still the initiation of mediation is still submitted to the voluntariness of the parties. These are the general rules of the mediation process. This is very important, as parties must attend the first meeting and the following mediation with the assistance of lawyers. I think this is very interesting because, and this is one of the consequences of making mediation mandatory. And probably this is also a strategy of the Italian legislature to include lawyers inside mediation. As we had a strong opposition by lawyers, the idea of making the assistance of lawyers mandatory in mediation had a good impact on the attitude of lawyers toward mediation. But as you can understand, it raises cost too, because parties need to hire a lawyer to participate in mediation. But parties also have to participate physically at the mediation meeting. If the parties enter in full mediation, they shall pay the mediation fees established by law. And if parties agree to enter in full mediation, the procedure shall be concluded in 3 months. But I have to say that no mediation proceedings concludes effectively in 3 months. Most of the proceedings last more than 3 months. I have time? Just a If the parties at the end of the mediation proceeding, find an agreement, the mediator shall draft the mediation report and attach the agreement. And if lawyers sign the agreement, this is an enforceable title without any need to go to the courts. It's just immediately effective with the signature of lawyers who certify that the agreement is consistent with public policy and mandatory norms. If parties cannot find an agreement, the mediator may submit a proposal and shall submit a proposal if both parties requires the proposal. And the party who refuses the proposal might be sanctioned by the court if the judgment at the end of the proceeding in court corresponds to the content of the proposal. So we have a sort of duty to settle, I would say, because if the party doesn't accept the proposal and at the end of the proceeding the judge makes the same decision as the proposal of the mediator, the sanction might be quite high. So I can say there is a sort of duty to mediate in this case. But I also have to say from a practical point of view that I am not aware of any decision of courts awarding costs and sanctions against a party who refused a proposal of the mediator. So it's in the law, it's in the paper, but it's not really common in practice. I would say it's not common at all in the practice. Well, mediation's fees are regulated by the ministry decree. The filing fee is 40 euros. No other fees are due if the parties do not proceed after the first meeting, while if the parties agree to proceed after the initial meeting, each party shall pay a mediation fee that is calculated upon the value of the dispute. This is not a very expensive fee, and on the other side, you can understand that the compensation of the mediator is not very satisfying because, for example, for a dispute, the value of which is between 25,000 and 50,000 euros, each party has to pay 400 euros. So imagining two parties, the mediation provider will gain 800 euros, and then this amount of money shall be shared with the mediator, independently of the number of meetings that the mediation will need to get to the end. And fiscal benefits are granted if parties attend mediation and find an agreement. Here you can see some statistics just to realize how important mandatory mediation can be, or at least is in Italy. The number of mediation is quite high. I just brought, yes, 5 minutes, okay. I just brought the numbers from 2016 to 2018. The green column is mandatory mediation, while the blue one is judicial referral, and the red one is voluntary mediation. You might even not see it, but there is also an orange column that corresponds to mediation clause mediation. It's not working at all, I can say. It's less than 1,000 per year. While you see, even if it's diminishing the number of mediation initiated in these last years, this is probably due to the economic crisis in Italy. So litigation is diminishing due to the general economic crisis, and we assist to a diminishment also of the number of mediation proceedings, as well as the proceedings in courts. I brought just the statistic of the Milan Chamber of Commerce, that is one of the main mediation provider in Italy, to show the outcome of mandatory mediation. As you might see, this is not so satisfying because 40% of cases, the defendant doesn't show up at the initial meeting. So you assist to a failure of mediation because the other party doesn't show up. Probably here, sanctions against the parties who doesn't cooperate are not so strong to convince the parties, but otherwise, raising this kind of sanction could be unconstitutional. In the 27% of cases, the parties just stop at the end of the first meeting. Again, this is probably the fault of the mediator who does not convince them. And 12% of the remaining case of the other cases just don't settle, while this is quite good, but the 21% of cases just settle at the end of the proceeding. Okay, I just want to make a conclusion. No, this is okay. Sorry. I just want to make a conclusion. How much this mandatory model is changing mediation in Italy? Well, in my opinion, there are many aspects affected by the mandatory model. The role of lawyers, the more formalities, less confidentiality, but I think the most relevant one is the role and responsibility of mediators. In my opinion, the Italian mandatory mediation model, with all its characteristics, increases the role and responsibility of the mediator. As if the system and the parties themselves have higher expectations about the mediators operating in a mandatory environment than in a voluntary one. I'm not sure about that. I would like to discuss that about. First of all the mediator has the role and responsibility to duly inform the parties on the nature and functioning of the mediation process and to help the parties to decide whether they want to go on or simply stop at the first meeting. This is a very positive aspect, as I said, as no one more than the mediator can instruct the parties and try to convince them on the benefits of the mediator, exploring their doubts, their fears. But this also means that the mediator who poorly conducts the meeting is somehow responsible for the failure of mediation toward the parties, toward the provider, and toward the mediation in general. Here, I'm not talking about civil liability, I'm just talking about responsibility, ethical, professional responsibility. But second, in this context, mandatory context, the mediator also bears specific obligations with regard to the certification of parties' attendance, the behavior they kept during the meeting, and has to conciliate this requirement with confidentiality. If there is a duty to mediate or at least to participate to the meeting and a sanction for those who fail to comply, then some sort of report must also be made, and this implicates that the mediator has to control the formal aspects of participation and might find himself in a position to disclose information regarding what occurred during mediation in clear conflict with confidentiality, being exposed to a higher risk of responsibility for violating the duty of confidentiality. And last but not least, I finish, even if the mandatory mediation models leave the parties free to settle or not, and the attorney, and leave to the attorney the responsibility to draft the agreement, still, in my opinion, this mandatory model increases parties' expectation about the mediators, also with regard to the agreement. The parties say, if we are forced to come to your table, so you have to offer us something that is valuable and efficient. So even if I think we are likely far away from establishing mediators' liability because mediation produced no settlement, well, I don't think it's not by chance that recently a court held the mediator responsible, liable, found the civil liability of a mediator for the invalidity of an agreement reached at the end of the mediator. I can't say if this is an isolated decision or if it will become a precedent. We don't have precedent, but somehow a precedent that could lead jurisprudence. But undoubtedly, it is an important signal of how the legal structure of mediation might change the same nature of mediation. Thank you.